Big on Terrence, presiding.
Thank you. You see that? Sorry I'm late. I got a new watch. I paid $49.95 for it, but it's, I thought it was high end, but I guess it's running a little slow, so.
Is it digital?
Mr. Durrell, have you, I think we're bringing over your client, or is that right?
It's my understanding he's
Still,
being transported here.
okay.
Over here mobile stuff.
All right. Can y'all hear me okay?
Yes, Your Honor, I can.
Good morning, Judge.
What happened to Mr. Gibbs's hair back there? Is that you, Mr. Gibbs?
Yes, Your Honor.
Okay.
Your Honor, Jennifer Flowers with RCC. Good morning. Here on behalf of Christopher Cluster. We had put him on today because he believed there was a drop charge statement coming, but the state has not gotten that. So we would ask just to move him back on to the pretrial docket. If we do get an amended offer from the state, we'll move it up. 8/26,
No objection.
All right. Where's my
the 30 days today.
calendar piece of paper? Yeah. August 26th.
Being on vacation.
Or if it comes amended with, like, would they take it?
Thanks. And Your Honor, this is Kevin Tyrone Russell. He's got 3 case numbers appointed. I went ahead and set this. He's made a motion for Nelson hearing, so I just thought it would be prudent to go ahead and set it for hearing.
All right, Mr. Russell, what is the problem you're saying with Ms. Flowers? Let me put you under oath. Please raise your right hand and be sworn. You swear the testimony you give before this court is true, so help you God.
Yes, I do.
Okay, thank you.
Your Honor, Phil, Ms. Flowers and Fish Counsel. I asked for the following. Number 1, downward departure. I never had one. Number 2, mental health court. Number 3, drug rehab. Never been to drug rehab. Number 4, negotiate offer. She said no to all the above. She would not ask. Number 5, she also stated she spoke to my dad recently. She never spoke to my dad, only once in the beginning of my 8 months of incarceration. On number 6, on June 24, 2024, Ms. Flowers was very aggressive in statement. She was tired of continuing her clients and has become aggravating and a nuisance. Number 7, she was trying to force me to sign without negotiating with state. Number 8, Ms. Flowers has refused to do anything I asked her to do. Number 9, Ms. Flowers showed me that she has no interest in working on my behalf. Number 10, Ms. Flowers makes negative statements concerning her clients. These are the 10 reasons why I feel Ms. Flowers is insufficient counsel on my behalf. Thank you.
Ms. Flowers?
Yes, Your Honor, just to respond, Mr. Russell was charged, he has 2 VOPs as well as a new law case.
Can you pull that microphone down a little bit?
I have negotiated with the state on several occasions. I actually was able to get him a really great offer. His new law, he's charged with trafficking in a substance that has a 7-year minimum mandatory sentence. It's a very clear-cut case. I was able to I did negotiate with the state for a guideline offer in lieu of a minimum mandatory offer. He did not want to accept that, so I told him that I couldn't make the state make an offer, that I had gotten the best offer I could from the state, and the options were to either accept the offer or set for trial, that I was prepared for trial. And at that time, he voiced his concern for a Nelson hearing. I have negotiated extensively on his behalf. I'm not a magician. I can't make up the facts in this case. I can only negotiate so far. And I do believe that Mr. Russell, our communication is completely broken down. I do meet with him, but he really doesn't listen to anything I have to say. So I don't remember what other allegations he was stating, but I have.
She says she's got a plea offer that comes off a minimum mandatory sentence.
My arrest was an illegal search, sir. She will not fight for that.
Your Honor, he was arrested on a warrant and searched on a misdemeanor warrant and searched incident to arrest.
State versus Dickey says you can only pat down the outer garments for weapons to protect the safety of the officers and others. The officer immediately went in my pocket.
Well,
I've explained to Mr. Russell I cannot file motions that I believe to be frivolous.
she's not ineffective, but apparently there's quite a breakdown here. So I'm going to find there's a conflict, but Ms. Flowers certainly is not ineffective, so I'll appoint another attorney. They may have the same argument. They may have the same situation. Ms. Flowers say that's not a proper motion. If that's the case, you're on your own. You don't get another attorney after this one, you understand, that I'm appointing? You're not an attorney, so you can represent yourself if you want to. And you may be looking at some serious time. What's the next person on the list? Charles Williams? I don't know. Who's Charles? That's not right. Jason Cobb. All right, court appoints Jason Cobb. If you don't get along with him for some reason, you're probably looking at being on your own, trying to try your case on your own. Okay?
Thank you.
All right.
Judge.
Prepare me an order, Ms. Flowers, if you
Yes,
don't
sir.
mind.
Yes, Judge. Yes, Your Honor. Good morning. Again, Jennifer Flowers with RCC on behalf of Cordell Thomas. We're here today on a motion to dismiss in case number 24CF24. I filed the motion, and if the court would allow me just to go through the brief points.
Okay.
Judge, forgive the state. We're going to ask for a continuance in this case. Ms. Leone is out of the country. She also needs to review a deposition that was taken in this case. So I believe it'd be prudent for the state to have an opportunity to review the transcripts or the recording of the deposition. So we are prepared to argue the motion to dismiss, but we're not ready at this time, Judge.
All right, when's our next, they say they're not ready, that the prosecutor that is handling the case is out of the country. So they need to have an opportunity, the person that's handling the case is not available. So when is the next miscellaneous?
I believe it's the 8th
8th
of August.
August, so that's just a week or so. She'll be back the 8th of August?
Ms. Leone indicated to me in an email just the end of last week that she would not be here on the 8th and said not to set anything for her on the 8th. So I had to reschedule something that I had said.
Oh, okay, so what is the next one after that? August 29th?
And Your Honor, I would ask if it would be possible, this is a older case. He is, I believe the case law is pretty clear. I understand that the state needs to review the depositions were actually done originally with ASA Glisson, and then she left, and then the case has gone to several different prosecutors. And I would just ask if the court would allow and if the state would accept this, if we could get those transcripts or recordings to maybe someone that could review them,
Well,
so that we
hang
don't
on
have
a
to wait.
second. He's here on, this is 24 CF 24, right?
Correct,
And he's being held on 24 CF 906, correct?
correct.
So he's sitting in jail on 24 CF 906 anyway, correct?
Well, he does have a bond. The bond is revoked in this case.
What's his bond on 906?
I believe it's upwards of about
Yes, sir.
50,000.
Yeah, but if there was, I was, like, she had come and told me that there was, like, she was gonna put in dismissal and actually for, like a $5,000 signature bond, Your Honor.
Well,
But,
our plan,
I didn't know, I didn't know this was, none of this was, I'm trying to get back to my school time in, Your Honor. I thought this was already gonna be just like.
well,
over
he
with.
did, I just found out recently, just yesterday, that Miss Leone was out of the country, so I wasn't able
Well,
to
you're
communicate.
you're in jail anyway on 24 CF 906. There's a bond set, which whether you can make or not, I don't know. What's the bond on 24 CF 24?
He had posted a bond and had he was out on bond and then was rearrested, and so his bond in this case was in 24 CF 24 was revoked. So we're just asking that as soon as possible, we could hear the motion to dismiss. I believe that once the state actually takes a look at it and is able to listen to these recordings,
We'll try
that they
to-
will agree.
See, I mean, if I dismissed it for some reason, if I find out it's dismissed, I mean, if I grant his dismissal, I don't know anything about, I hadn't heard any facts yet, but if I grant his dismissal, he's still sitting in jail on 24 CF 906, correct?
Correct, unless he's able to post that bond.
Judge, if we do set it for August 8th, I'll take a look at the evidence and the motion to dismiss, and I'll be prepared to argue it on August 8th. I don't want to
Okay.
have, you know,
We'll bring it
undue
back August 8th.
prejudice against the
Thank you, Mr.
defendant.
Strauss.
So we'll bring it back August
August
8th.
8th.
Your motion to dismiss is set for August 8th,
Thank you, Your Honor.
okay? That's just a week.
Okay.
Okay, thank you.
Thank you, Judge.
So what are we doing?
Coming back August 8th.
August 8th.
So is one of the cases already dismissed? Is there no action on one of them?
No,
No.
I mean, we're coming back to hear your motion to dismiss on August 8th.
The prosecutor that was supposed to, is on the case, is out of the country.
So
Out of
another
emergency,
another
she's out of the
prosecutor is
country.
going to take over and argue the case on August 8th. Okay? Thank you.
No, we have deposition set.
All right, thank you.
Thank you. And I believe that's all I have on, okay.
That's it?
Yes. Thank you, Your Honor.
All right,
I have a couple out of custody, if I may, Your Honor.
all right, Mr.
First,
Gibbs.
first out of custody, Judge, I have Mr. Bobby Bean.
All right,
Your Honor, Mr. Bean is present approaching. We've reached an agreement, if I may approach.
the State of Florida versus Bobby Moore Bean, 24 CF 29. Mr. Bean, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
You want to enter a no contest plea to the charge of driving with license revoked, third-degree felony, and leaving scene of an accident without giving required information, a second-degree misdemeanor. So you want to enter a no contest plea to those charges, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs done for you on your case?
Very happy.
Court finds the plea is freely and voluntarily entered. Court accepts it on count 1, 12 months probation. Adjudicated guilty, $100 cost of prosecution, $415 court costs, $150 PD fee. Must be on GPS monitor at no more than $1 per day. On count 2, you're sentenced to time served. Adjudicated guilty.
We'd request to waive cost of supervision on that supervision, Judge.
Waive cost of supervision
Thank you,
granted.
Judge.
Okay? Thank you.
Brandon, and here you go. Thank you. Judge, the other person that I have out of custody this morning is Mr. Delroy Durham.
Durham?
Durham, yes, Your Honor. 24 CF 1417, 24
Okay.
CF 1419. We filed a motion to recall the KPS. He was supposed to be here Thursday, Judge, for an arraignment. Unfortunately, did not make it. I believe he was informed that he had quote-unquote court the 26th and had confused that with August 26th. So we're asking to recall the KPS. He's been in contact with our office. It's not unlike him. It's unlike him, actually,
Has
Judge.
he been
to this court.
arraigned?
He has not been arraigned yet. We would otherwise enter a not guilty plea.
All
The
right, well,
state
this,
has no objection, Judge, to
okay,
recalling the
24
KPS.
CF 1417, Mr. Durham, you're charged with trafficking in meth, possession of a weapon by a convicted felon attempting to flee police officer, drug possession without a prescription, false ID to a LEO, and driving with suspended license. And it looks like in 24 CF 1419, possession of a controlled substance. So your attorney's pledged you not guilty. Asked for a jury trial, so we'll set you for, what's the day, September 6th?
Today, Judge, is July 30th. The next is August 26th, and then we have an October pretrial after that.
Set it for October. What's the pretrial?
I believe
Somehow this
that's
is
going to be October 31st.
These dates are not. October 31st,
Or no, I'm sorry, October 28th.
October 28th? Okay.
That's our next.
I'll recall the capias.
Thank you, Judge. There's both cases, 24-14-17 and 24-14-19. Are you showing any others? Okay. Those were, yes.
Yeah.
Thank you.
Don't mess
Thank
up,
you.
because I'll have to, don't, show up, okay?
Right, yes, sir.
Show
I
up.
just got confused
Okay.
with the dates.
Yeah, get with Mr. Gibbs.
Yeah.
And so your next court date is October 28th,
Thank you, Judge. Yeah.
okay?
Give me a call. Oh, and Judge, I think we need to vacate the forfeitures and reinstate the bonds. I know his bondsman contacted me. I'm not sure if that's something that
Send me
we
an
do.
order.
We
I'll
can send you an
vacate
order.
the forfeitures and reinstate the bonds.
Thank you, Judge. We'll send an order. Yeah, give me a call.
If y'all get the case worked out, move it up.
Absolutely, Judge.
Oh, okay.
Well, that's-
Mr. Durrell?
Is he already here?
Your Honor, I have already gone over the plea with Mr. Bunkley. This is going to be a written plea. I just need him to sign it real quick. If I may approach, Your Honor?
State of Florida versus Arasha Bunkley, 2015 CF 998. Mr. Bunkley, would you please raise your right hand and be sworn? You swear the testimony you give for this court's true, so help you God?
Yes, sir.
Okay. You want to enter a no contest plea, the charge of possession of a controlled substance without a prescription?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of your rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Durrell did for you on your case?
Yes, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. Sentenced to 18 months, Department of Corrections with credit for time served, standard fines and costs, concurrent with 2016 CF 1188, and adjudicated guilty. Okay? How much time have you got already?
How much time in do I have?
Yeah.
Close to,
On this case, not on this.
I think I bonded out on this case, sir, like the next day. So, maybe like 3 weeks now since I've been back
Okay.
here.
All right, well, good luck to you, and when you get out, don't break the law.
Yes, sir.
Okay,
Thank
thank
you,
you.
sir. Yes, sir.
I believe that's all I have today, Your Honor.
Thank you.
Morning, Your Honor. Tim Gibbs on behalf of Dakota Coffee. Judge, this is 23 CF 2767, 23 CF 2768. We've reached an agreement, if I may approach.
All right. This is State of Florida versus Dakota Joseph Coffee, 23 CF 2767, 23 CF 2768. Mr. Coffee, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God. You want to admit that you violated probation in these two cases?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Did you read the plea agreement form yesterday?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea?
Yes, Your Honor.
Anyone force you or threaten you to enter this plea?
No, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Court finds the plea is freely and voluntarily entered. Court accepts it in 23 CF 2767. Probation is reinstated, modified for the remainder to be on community control. $100 cost of prosecution, $150 PD fee. Enter and comply with the Responsible Fatherhood Initiative Program with DCF. Counts 2 and 3, the court's going to revoke and terminate. And time served. And in 23 CF 2768, the court's going to revoke and terminate and sentence you to time served. Adjudicated on all cases, all counts.
Thank you, Judge.
Guilty.
I'm
Okay?
sorry, that should be withheld still on the felony where he was reinstated, Judge.
Oh, all I saw, you got withheld and adjudicated, so
Yes, Judge.
it kind of confused the old judge here.
Sorry about that.
So which one is withheld?
The only one that's staying withheld, Judge, is the felony count on 2767 where his probation was reinstated.
All right,
That count.
23 CF 2767, adjudication is withheld. I'll make an arrow to that one.
I appreciate it. Thank you.
And then adjudicated is on to 23 CF 2768, correct?
Yes, Your Honor.
Okay.
Thank you, Judge. Get your fingerprints and you'll be good to go. Thank you.
Who we got next? Davis?
Yes, Your Honor. I think we're pulling him now. Your Honor, Tim Gibbs on behalf of Jonathan Corey Davis. Judge, this is 22 CF 2802. We have reached an agreement, if I may approach.
All right. This is State of Florida versus Jonathan Corey Davis, 22 CF 2802. Mr. Davis, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Sir.
You want to enter a no contest plea, the reduced charge of aggravated battery with deadly weapon causing great bodily harm, a second-degree felony, correct?
Yes, sir.
And also, no contest to giving a false name to a law enforcement officer, first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
I did. Yes,
Did
sir.
anyone force you or threaten you to enter this plea?
No, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 1, the reduced charge of aggravated battery with deadly weapon causing great bodily harm, you're sentenced to 51.15 months DOC with credit for time served, $100 cost prosecution, standard court costs, $150 PD fee to collections. Restitution is ordered. Court reserves jurisdiction as to the amount for a period not to exceed 180 days. On count 2, the misdemeanor, you're sentenced to time served, adjudicated guilty on both counts. Both counts. And how much time have you got in already on this?
It's got about 21 months, I think, Judge.
21 months. So You got a good portion of it
Yes, sir.
done. So when you get out, just don't break the law, okay?
He does,
I promise you I will not.
he does have a Leon County hold that we were hoping to be able to try to address as well, but of course, that's Leon County. I was not able
Yeah,
to
I
find
can't
it.
help you on Leon County, but,
Hopefully he can get over there and resolve
maybe,
that before he
yeah.
goes.
all right, well, good luck to you, and when you get out, I don't know what caused all this, but, just don't break the law, okay?
Yes, sir.
Thank you.
Good luck. Your Honor, Tim Gibbs on behalf of Mr. Ronald Franklin. Judge, this is 24 CF 1283, if I may approach.
All right, this is State of Florida versus Ronald Dale Franklin, 24 CF 1283. Mr. Franklin, you want to enter a no contest plea to the charge of possession of a controlled substance, a third-degree felony, correct? Correct?
Do you want to enter the plea today?
Yes, sir.
Did I swear him in?
I don't think you
Would
did
you
yet,
please
Judge
raise
Hannon.
your right hand, Mr. Franklin, be sworn? You swear the testimony you give for his court's truth, so help you God.
Yes.
You want to enter a no contest plea to the charge of possession of a controlled substance, a third-degree felony, correct? Did you read and sign this plea and sentencing agreement form? You did?
Did you just answer out loud?
Oh, I'm sorry.
Did you sign that form yesterday?
I did, yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Gibbs has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it, sentences you to time served. $100 cost of prosecution, $5.15 court costs, $150 PD fee due within 180 days. Adjudicated guilty. And order you not to break the law in the future. That fentanyl, I hear, kills people pretty easily, so stay away from that. Thank you. They listen, too, when I order them not to break the law.
That's enforceable, for sure.
I think that concludes my business, Your Honor, if I may be excused.
All right,
Thank you.
Ms. Rivers? This is State of Florida versus Robert James Strauss, 20 CF 3247 and 21 CF 247.
Your Honor, there's a direct conflict that would prevent us from representing Mr. Strauss. He's a complaining witness in a case that I already have. Our office is in the process of filling out paperwork for a conflict. I did tell Ms. Flowers about it this morning when she was here.
All right, if there's the public defender's certifying they got a conflict, so I got to let them off and put the Regional Conflict Council attorneys to represent you, okay?
We'll send a motion in
That'd
order,
be
Your Honor.
Ms. Flowers, and she'll be up to see you, and when is this next court date?
If you want to put it on for the 8th, then that would give her an opportunity to meet with them.
The 8th?
Is that the next court date, or is it the 6th, the August?
It's the 8th, I believe.
Is he going to enter a plea or something, or?
Your Honor, we definitely have an offer that I can convey to Ms. Flowers that probation has
Okay, bring it
presented.
back August 8th. Next week, maybe get it resolved. Okay, thank you. This is 24 CF 1284, State of Florida versus Kevin Paul Lack.
Yes, sir. Judge, I believe this is on for a bond hearing.
All right.
Sorry, Judge, just looking for my notes. Judge, let me just take testimony then from Mr. Lack.
What bond is he under already?
Let me see here. Judge, if you can pull up my motion or give me a second, let me grab my computer and I'll pull it up. Because I've got all that in the motion. Here we go. All right, Judge, he's been incarcerated since June 2nd. His current bond is $4,500, but he cannot make that bond. He's asking for a signature bond. He's self-employed as a handyman. He resides here in Crestview and has lived in this area for 19 years.
Is that 4,000 on one count and 500 on the other?
Sounds about right. The other count is DWLSR, Judge.
Yeah.
That would be my guess,
Has he
Judge.
got a prior record?
Judge, I have his prior record in front of me. I don't want to interrupt.
No, you're fine.
All right, go.
So this is not Mr. Lack's first time in the court for domestic violence battery. He's also failed to appear. So the bond statute provides that when determining when to release a defendant on bail or other conditions is the nature and the circumstances of the offense charged. Mr. Lack's wife is on hospice. She's on oxygen, and what's alleged is that he chokeslammed her. So I believe the nature and the circumstances are malicious. The second one is the weight of the evidence against the defendant. Well, we sent over a stipulated order requesting to perpetuate the victim's testimony because she is on hospice and because she's not on oxygen. She spoke with my office earlier, and she is dying, so she's not able to make it here today. She is concerned with her safety, given the conduct of the defendant. Because she's on hospice at her home, at the marital residence, essentially, she doesn't feel safe if he's to be released. Furthermore, he's already sent a letter to her, and he addressed it to his sister or somebody's sister, but it's addressed to the marital residence, and no one's sister lives there. And he wrote, essentially had contact. At very minimum, it's third-party contact because he asked his sister to ask the wife, for forgiveness and to drop the charges. But the state's position is this is contact. It's addressed to
Does he have a failure to appear on this case?
He does not have a failure to appear on this case, Judge, but he has, if I may go through his record, 2020 he got a DUI, and he had a failure to appear in that. I don't believe the state had any action, but nevertheless, he failed to appear at a scheduled court date. 2020, another contempt of court violation against protection against domestic violence, forgive me. So even when the court imposes rules to make sure that he does not harass the witnesses or harass the victims, he wholly fails to listen to the court. And the only thing that's going to stop him from speaking to the victim or harassing the witness is him being behind bars, Judge, and having a cash professional bond. And I believe the first appearance, Judge, got it right on his.
That contact or alleged contact is, I'm just going to leave the bond the way it is.
Yes, sir. Just wanted to correct. It's $1,000 on the DWLS and $3,500 on the other case, Judge.
All right. Thank you.
Thank you, Judge.
Thank you, Judge.
Thank you.
Right. Judge, you've got Destiny Lige on the docket. It's for a competence review. I brought up the court's previous order in the case. Department of Children and Families was ordered to provide a report prior to today, and today's court date was referenced in the order. My secretary reached out to them last week because we still didn't have an order, and we've not had a response that I'm aware of. My secretary was out Friday and is out yesterday and today.
Who is supposed to prepare the report?
Department of Children and Families is whose custody she's under. She's in the Florida State Hospital, and they were...
We'll set this for August 26th.
Judge, I'm going to suggest that we set it not on a docket day because it's going to be kind of crowded. Maybe set it on the 8th.
All right, the 8th, but that's just a week from now.
Well, if you want to set on the 26th, that's fine, Judge.
Well, what about August 29th?
That would, I think, probably be better. It does give them a little more time, but...
August 29th, that's a miscellaneous day, I think.
And we can move it up if we get the report.
Yeah,
Yes, sir.
all right. Next one, Michael Joseph Manning. Bond hearing.
Yes, sir, Judge. Sorry, Judge, I printed stuff out and it did not make it in the file.
Wasn't Mr. Manning just in court like last week or something, out of custody?
No, Judge, he's been in custody for quite a while.
Okay.
He was out of custody long enough to violate his pretrial conditions, though.
My understanding is that one of the cases either has been or is about to be null-prossed, and is what we have remaining the possession of controlled substances.
That is correct.
All right, and you're seeking 1129 on that?
I believe I'm seeking 12-1, but I would allow 1129.
You can't give him 12-1 on a misdemeanor.
I have him on a possession of controlled substance right now, so that's not a misdemeanor.
Okay, all right, so you did not null-pross the whole case, you just have
So there was two
null-pross the
cases.
felony on the other case?
Yeah,
Okay.
I null-prossed the felony and the narcotic equipment. I null-prossed that whole case, but he has a new case. When he was out on bond, he picked up new charges. And so the pattern of behavior of the defendant is stealing and doing drugs and being caught with drugs. So we got to give our merchants and our business owners a break from Mr. Manning.
Are we on 24 CF 1268?
Yes, sir.
And so I have possession of a controlled substance without a prescription, a third-degree felony, and possession of narcotics equipment. I think that's a first-degree misdemeanor.
It is, Judge.
And you're null-prossing which one?
It's a different case.
It's on a different case. The judge found no PC for the felony on a different case, and so he's null-prossed that. I did not file a motion on that case because he already had an ROR bond on the
Why don't y'all,
remaining
why don't we
count.
bring back Mr. Manning on August 8th, and maybe you can work out a plea?
Give me just 1 second.
The state does not plan on departing from its offer, just based on the conduct of the defendant, Judge.
It means it's dismissed.
Okay.
All right, Judge, let's just go ahead and have the bond hearing at this point, because unless the state's going to budge on the 12-1, I don't think Mr. Manning's going to budge on his request for probation. The only other thing I could do is talk with him about a straight-up plea and go over that possibility with him.
Is there a suspended sentence, like a 3-year probation with suspended 24 months? or
Judge,
something?
he's not going to be able to do probation because there were rules in place for him to not break the law, and he broke the law.
All right, what's the bond hearing motion?
All right, so Judge, he's been incarcerated this time since June 1st of *24. He's only got a $2,000 bond, but he can't make it. He's being asked to be allowed to sign his bond. He's currently unemployed, but he resides with his mother, Cara Bain, and he's lived in this area all his life and has substantial ties to the community.
And this bond is what?
His bond currently on the case that we're seeking a bond reduction on is $2,000. He's already got an ROR on the remaining count of the other case.
Cash or professional?
That's what it currently is, Judge, is
All right, you
$2,000.
put up $200 and get out, so I'm not going to change the bond.
Thank you, Judge.
All right, Judge.
So did we continue to the 8th
No, you won't come back until the 26th.
of August?
Yeah.
All right, yeah, I'm not wanting to take.
Okay. Oh, Dwayne Moore. I'm sorry, I was looking at Jeffrey Keith Moore. Judge Dwayne Moore, you do have a report from DCF on him. They're recommending that he remain there at the hospital. He's apparently making reasonable progress, but he's not ready to be released at this point.
All right.
So what I'd suggest is we set another 6-month date.
No objection.
All right, what's a court date 6 months out?
Madam Clerk, do you have a date for us?
Sometime in January, like January 25th?
What we could do is set for the last date that we have, and by that point, either continue it, or if we have a report already.
We got court December 26th. We're not having court December 26th, are we?
I'd rather not,
Do we have any cases?
Judge.
There's no cases?
I think we have a court date after every holiday.
December 5th.
Okay. Thank you, Judge.
The
I
only
believe
one
my
that would
secretary
come
will
to
do the order.
Only one that come to December 26th is Mr. Berry, because he doesn't get any toys on. He's always in a grumpy mood, so he'd be happy to come to court. All right, Jeffrey Keith, Strauss, or Moore.
Judge, this is another motion for bond reduction.
All right.
Mr. Moore was originally released on one of the cases and then had his bond revoked. He's been incarcerated since June 11th. His bond was revoked in 24 CF 1046. He has a $2,000 bond in 24 CF 1357 and a $1,000 bond in 24 CF 1358. He's requesting a signature bond in all his cases. He was employed with Walmart, but believes that he no longer has that position due to being in jail, but he does believe he can become employed at Taco Bell if released. He will reside at 5707 Fairfield Road, or Fairchild Road in Crestview, and has lived in this area for 20 years.
His bond was revoked for some reason?
It was, Judge, he indicates that he was told that he could still have contact with the family, and he went over there, but apparently there were pets there, and he's not supposed to be around the pets. I don't think there's an allegation he was left alone with them or anything like that. But then when he was arrested and taken to jail, they found contraband on him, and that resulted in the other two cases.
What does the state say?
So I have a report from Officer Tiffany Lacroix. Said Jeffrey Moore was released on bond for charges of aggravated animal cruelty. Defendant was released on a $35,000 cash or professional bond with pretrial supervision on 11/7/2023. The defendant has violated the following court-ordered conditions of his bond. Within 24 hours of his release from jail, and each Tuesday thereafter, report to Okaloosa County Pretrial Service as scheduled. No contact with the victim, not to be within 500 feet of the victim's home, vehicle, employer, place frequented, and notify pretrial of any changes to the address, contact number, so on and so forth. How he violated the specific facts are per Crestview Police Department, incident report number CPD 24 OFF 001850, submitted to pretrial service. The defendant was found to be in direct contact and possession of domestic animals that were located in the same hotel room the defendant was found to be residing. So the victim in the case, believe it or not, is a cat, and he was with the same cat. So specifically told not to be with that cat.
That's not true.
Okay. Judge,
The animal involved in the case was being returned by Animal Services. When it was discovered the defendant was also staying in the same room and the other domestic animals were seen roaming freely around the same room as the defendant. These actions are a direct violation of his current bond and pretrial release conditions. So we have put conditions in place to ensure the defendant's conduct is that what we want of somebody who's not incarcerated. And he has failed to do so. He's violated the specific conditions of his bond. And I believe the judge...
Bond on 24 CF 1046.
1046 is the aggravated animal cruelty case, and the bond is $35,000 cash or professional, which has been revoked since.
Judge, if you give me a chance to be heard.
He wants to say something.
Your Honor, I did not, there was a huge miscommunication whenever it came to all this. Whenever I first got on pretrial, I had contacted my pretrial officer and I had asked her, I said, me and the mother, we got kids together and everything. I said, as long as the cats, because me and the mother are still together, I was like, as long as the cats are not in the same room, because we got kids together, they were still going to school around that time. I was like, is it okay if I can, still go over there to, help make sure my kids get on the bus and stuff like that? She advised me, she said yes, as long as I was
Objection,
around.
Judge. This is hearsay.
I have no
Self-serving
reason, I have no
hearsay.
reason to lie.
Statement by a party opponent, theoretically.
And needless to say, whenever she had said that, I was under the impression that I was okay to go over there to just take care of my kids. I wasn't even necessarily staying over there. I got proof that I was staying at other places. I was just over there at the time because I was helping take care of my kids. Whenever I found out that I could not be around animals at all, period, because, that's what the thing had said, and I was told a little bit something different. The mother of the kid, my kids, she had actually got rid of the animals and had them go stay somewhere else. So whenever I got arrested, there was no animals there because I wasn't even trying to violate pretrial or anything like that. Had I have known that I could not be around animals at all, I would have never done it to begin with because I'm not the type of person to just be violating and doing stupid stuff. Like I got...
Prior record?
No, Judge, he doesn't.
I haven't been in trouble in years. Sorry.
You haven't been in trouble for years?
I have not been in trouble in years. Like it's been
I
a
should
while
have a
since I've been
copy
in
of
trouble.
his score sheet here somewhere if the
Who set
state
the
provided it.
$35,000 bond?
Judge, that would have been the first appearance, Judge. And at the time, they were thinking this cat had been very seriously injured. Since then, we've gotten a copy of the veterinary report. If I can, and I sent this information to the state via email back on July 1st. A review of the veterinary report, particularly page 5 of 16, radiographs, those are x-rays, no abnormalities seen. which means no fractures. Patient not showing signs of head trauma at this time. Then a little bit later on, the initials JB, no sign of head trauma. Page 15, neurological, normal.
How long has he been how long has he been in jail?
He's been in jail since, I believe, the 11th, Judge. I've got it in my motion.
11th of what?
July. Yeah, or June 11th, 2024.
And the allegations, the reason it's filed as an aggravated animal cruelty is the allegations are his son watched the defendant like slinging the cat in the bathroom of the hotel room, which would likely cause serious bodily injury.
Sorry,
But
Judge.
what the defense is stating,
Remember, Mr. Williams, these inmates are sensitive.
Yes, sir.
Okay, they're sensitive.
but what Mr. Williams is stating, as far as the veterinarian report, it is correct that the cat is in good health now, is with the owner.
All right, well, what I'm going to do is,
And Judge, we obviously dispute the facts.
what I'm going to do is change his bond to on 24 CF 1357. He has no failure to appears, right?
That's correct, Judge.
No, Judge.
2,000 signature on 24 CF 1358, 1,000 signature, and on 24 CF 1045 or 6, is it 5? 6. 24 CF 2000, for some reason, I'm 24 CF 1046, I think, correct?
Yes, Judge.
3,500 signature.
And Judge, we would object to that bond since he received a cashier professional on the first time and he violated. He should still receive a cashier professional.
Okay. 3,500 signature.
Thank you, Judge.
And no contact with cats
Any domesticated animal.
or any animal, domestic animal. Yes.
What
You
about,
just won. You want to take a chance on unwinning?
kids go and stuff, like as long as I'm not in the room, if I'm outside of the room, is that okay? Or
Judge, one of his issues, he's got a dependence, either an injunction or some sort of family law case pending. So that's something that I don't think the court's imposed any restrictions on him seeing his kids, but he'll have to address anything dealing with the family law case in front of that family law judge, and you've got a Zoom hearing that's already scheduled on that.
Yeah, I can't let you go in front of your kids or whatever it is if another judge has said you can't go. All right?
All right, so he's not put any
You
restriction
want
on you
to
being
stay in
around
jail
your
and
kids.
make sure you don't get around them, but
no,
I'm letting you out on signature. Don't go around them. Obey whatever the other judge said do, okay?
Yes, sir.
If they say you can't be around them, you have to get that judge to give you permission, okay?
Thank you.
Okay.
All right.
I think I got your paperwork here. I tell you what, just hang on to him for a minute so I can get his paperwork back to him. He handed me some, did you grab those papers already?
No.
Okay. Judge, I think I only have one more case.
All right, Amanda Lee Naderos.
Here we go. Hey, Stephen. This is his paperwork. Over next to me. Judge, I'm going to enter a denial for her, and we'll need to set her for another hearing. We're looking into some alternative sentencing options.
All right, this is 21 CF 115, State versus Amanda Lee Naderos. What about,
Judge, part of that's going to be looking at different places that she can go. I did send an email off on it already, but I'm going to suggest we place it out further than 8/8.
What about August 29th? Do we have?
I think that'll be sufficient, Judge.
Okay.
Okay.
All right, thank you. All right, anybody else? Mr. Gibbs, you got
Your Honor, I
something?
would like to call Mr. Franklin that we sentenced earlier. I just wanted to make the record clear that he has 180 days to pay his court costs.
Okay.
Got no objection to that.
All right, Mr. Franklin, is that right?
Judge, it was 24 CF 1283. Number 9 on my docket,
Ronald
Judge.
Dale Franklin on 24 CF 1283. I'll give him 180 days to pay his court costs, or they go to a judgment.
Thank you, Judge.
Thank you.
Good luck. That's all I have. Thank you.
What else we got? Is that it?
I'm done.
Thank you, Judge.
Thank you, Judge.